Ms. Williams, you said,
We can hear you now.
okay. Is the live stream initiated?
No,
Okay. So you didn't even hear me say initiate the live stream.
no.
Hey, everyone on the call, go to your commissioners and beg them for the Dallas County District Bench to get an upgraded Zoom. That's all I could come up with. This is terrible. I don't know what's happening with Zoom. It's horrible. Write your commissioners. Okay, I'll try to keep a lookout for if it comes off again. I'll try to put it up a little bit higher so I can see the light. All right, let's go. We are on the record in cause number 2015614. This is the matter styled Bradley Miller versus Virginia Dunn et al. Counsel, please state your appearances. And first, of course, Mr. Miller, your name for the court's record.
Bradley Miller, plaintiff, pro se.
Thank you. Counsel for defendants Dunn and Findlay.
David Findlay, for defendants Tally Dunn and David Findlay.
Counsel for defendant Plumley.
Scott Graydon for Judge Plumley, Your Honor.
Counsel for defendant Judge Diaz and Dallas County.
Earl Nesbitt on behalf of those defendants, Your Honor.
Counsel for Patricia Rochelle.
Michael Rochelle for Patricia Rochelle.
Counsel for the estate of Marianne Michalopoulos Rousseau.
Elena Eric for the estate of Marianne Michalopoulos.
Counsel for the Hockaday School.
Jennifer Littman on behalf of the Hockaday School, Your Honor.
Counsel for defendant Shagru.
Dalton Harris and Laura Sherry, Your Honor.
Is there anyone that I have overlooked? All right, then we are ready to proceed on defendant Dunn and Findlay's Rule 91A motion to dismiss. Counsel, you have the floor.
Thank you, Your Honor. I believe Ms. Rochelle's motion is also set for hearing at this time. Since Ms. Rochelle and I basically have the same defense of attorney immunity, Mr. Rochelle and I have conferred, and he's asked me to present the argument for both Ms. Rochelle and for myself on that issue.
All right, fair enough.
Beginning with, Your Honor, this lawsuit should have never been filed in any court against any of the defendants in this case. When you take Mr. Miller's petition and analyze the factual allegations contained in his petition, it becomes clear that the only reason this lawsuit exists is because Mr. Miller is unhappy with the orders that have been entered in his family law case. He is asking this court to overturn orders that neither the Dallas Court of Appeals nor the Texas Supreme Court nor any of the federal courts have done when presented with the opportunity to do so. As a threshold issue with regard to defendants Patricia Rochelle and myself, every act alleged by Mr. Miller that was committed by Ms. Rochelle or myself, as outlined in his petition, was in our rendition of legal services as Ms. Dunn's attorneys in the family law matters. Although Mr. Miller tries to argue that his allegations fall into some exception to attorney immunity, Mr. Miller misunderstands the type of conduct that falls within the scope of attorney immunity. If the court looks at both the Canty-Hager LLP versus Byrd case, and that we cite in our in our motion to dismiss, and the Youngkin v. Hines case, which Mr. Miller cites in his response, both of which are Texas Supreme Court cases, the focus of attorney immunity is on the kind of conduct at issue rather than the alleged wrongness of the conduct. The kind of conduct is things such as filing pleadings, presenting orders to the court for entry, negotiating settlements. Those are the types of things that all fall into the category of acts taken and communications made to facilitate the rendition of legal services to the client. That's the legal standard for attorney immunity. For both Ms. Rochelle and myself, every act that Mr. Miller has alleged in his petition was in our rendition of legal services for Ms. Dunn. He does not allege one act by either Ms. Rochelle or myself that falls outside of the rendition of legal services to Ms. Dunn as her attorneys. Moving on to the motion to dismiss, he alleges 10 counts. The first 5 counts against Ms. Dunn, Ms. Rochelle, and myself are for constitutional right violations. As I believe Ms. Leyendecker and Ms. Taylor's attorney brought to the court's attention and in their hearing to dismiss, he's suing private individuals for constitutional rights violations. That's not a valid cause of action under federal law. In his response, Mr. Miller asserts that he will be amending his petition to file under 42 U.S.C. 1985. However, he's not done so. Further, Mr. Miller will not be able to plead facts sufficient to establish a cause of action under 42 U.S.C. 1985 because that statute requires that there be some racial or perhaps otherwise class-based invidiously discriminatory animus behind the conspirator's action. That is a direct quote from United Brotherhood of Carpenters and Joiners of America versus Scott. And that is a 1983 U.S. Supreme Court case, and the citation is 463 U.S. 825. That particular citation is on page 834. The court should dismiss the first 5 counts because those claims are not supported by either law or fact. In his response, Mr. Miller acknowledges that he does not have a valid cause of action for count 10, which is the malicious prosecution, because he has not prevailed in any of the underlying actions below. Count 10 should be dismissed because even Mr. Miller acknowledges he has not satisfied the requirements to plead that cause of action. As to count 6, Mr. Miller has failed to plead the elements of fraud. The allegedly false statements Mr. Miller alleges were made have to be made to Mr. Miller, not to anybody else. The false statements have to be made to Mr. Miller. He doesn't allege any false statements in his petition that were made by any of the defendants in this case. Mr. Miller must also allege that he relied on representations made by either Ms. Dunn, Ms. Rochelle, or myself. He's not pled any reliance. Mr. Miller's claim for fraud therefore is insufficient and doesn't meet the requirements in either law or fact and should be dismissed. In count 7, he fails to plead any elements as to the conspiracy to defraud. In his response to the motion to dismiss, he claims that he will be able to establish this under 42 U.S.C. 1985. However, the United States Supreme Court has laid out the elements that he has to prove. First, he has to prove that there's conspiracy. 2, he has to prove that the conspiracy is for the purpose of depriving, either directly or indirectly, any person or class of persons of equal protection of the laws. 3, an act in furtherance of the conspiracy. And 4, whereby he's injured or deprived of any right or privilege of a citizen of the United States. The Supreme Court laid that out in Griffin versus Breckinridge in 1971. The citation is 403 U.S. 88. And those elements are laid out specifically on pages 102 and 103. And as stated earlier, he has to, in order to establish the second element, he has to show that there's some sort of racial or otherwise class-based invidiously discriminatory animus behind the conspirator's action. He's not going to be able to establish that. And number 1, he hasn't pled it. And number 2, he's not going to be able to establish it. So in addition to count 1 through 5, count 7 should be dismissed. Count 8, Mr. Miller claims negligent infringement on his rights. However, Mr. Miller has to first plead that there's some duty that has been owed to Mr. Miller by the defendants that has been breached. Mr. Miller's response, he doesn't even address his failure to identify the duty in his response. I went through his response just a few minutes ago, Your Honor. It's not there. Without any identification of some duty owed to Mr. Miller, he's not pled a viable cause of action for negligence. Count 7 should be dismissed. Finally, count 9, he's alleging intentional infliction of emotional distress. But as the court is probably well aware, the conduct alleged has to be so outrageous in character and extreme to the degree as to go beyond all possible bounds of decency. Mr. Miller hasn't identified or pled any conduct that meets this definition. Mr. Miller's response focuses on the fact that he's not seen his daughter in 3 years. But by his own admission in paragraph 155 of his petition, he's had every opportunity to exercise supervised possession of his daughter, but he refuses to do so. His focus on count 9 is on the outcome of his decisions, not on the conduct of the defendants in this case. Count 9 should be dismissed. Moving on to Ms. Dunn's defense of res judicata. In paragraph 26 of Mr. Miller's petition, he lays out each and every cause number of the litigation that's ensued since she's filed her petition for divorce from him in 2013. Paragraphs 29 through 63 all took place during the divorce. In paragraph 62, Mr. Miller admits that the divorce decree was entered on April 2nd, 2014. Mr. Miller also admits that he signed a mediated settlement agreement on the divorce on February 26, 2014. Under sections 6.602 and 153.0071 of the Texas Family Code, a party is entitled to judgment based on the terms of the mediated settlement agreement. Judge Plumlee simply signed the final decree of divorce on April 2nd, 2014. Mr. Miller never directly appealed the final decree of divorce. Therefore, it's res judicata as to anything that happened in connection with the divorce. Mr. Miller's complaint talks about the civil suit that Ms. Dunn and her gallery filed against Mr. Miller for violations of the Texas Uniform Trade Secrets Act, the Interception of Communications Act, the Texas Theft and Liability Act, and the Harmful Access by Computer Act, as well as invasion of privacy. A contested hearing was held on a temporary injunction that was granted by the court. Mr. Miller, by his own admission in the pleadings, in this case, appealed that decision. The Court of Appeals affirmed the injunction, only modifying 2 of the prescriptions, taking the last 2 prescriptions out, but leaving the other 5 points in the injunction in place. Mr. Miller did not appeal that to the Texas Supreme Court. Any complaints he has about the allegations contained in paragraphs 70 through 84 of his petition are barred by res judicata. Paragraphs 85 through 125 of the petition addresses events prior to and leading to Ms. Dunn's suit to modify a parent-child relationship that was filed in April 2015. This is the case that led to the October 18th, 2016 trial, where Judge Plumlee ruled on the record at the conclusion of the hearing what her judgment was going to be with regard to the modification of the parent-child relationship. She rendered that day. She ordered the parties to prepare an order. Mr. Miller refused to sign the order. And then on the day of the hearing of the motion to enter, Mr. Miller attempts to remove this case to federal court. As Mr. Graydon rightfully stated in his argument on this plea to the jurisdiction, the court had retained jurisdiction because Mr. Miller's removal was wrongful under the federal statute. We join with Mr. Graydon's letter brief that he submitted to the court yesterday, and actually the cases he cites are exactly on point because Mr. Miller, there's no ascertainable standard here. It's not like a discovery rule. I mean, he's tasked with having knowledge of the rules of procedure when he represents himself. He failed to do that in 2015 when he was served with citation. His removal wasn't timely. The federal court dismissed the case for lack of jurisdiction. The Court of Appeals dismissed his appeal for lack of jurisdiction, and the Supreme Court denied cert. Everything related to the November 16, 2016 order is barred by the doctrine of res judicata. Moving on to the points of his petition where he talks about the enforcement of child support. He was served with citation. He appeared. The court appointed a lawyer, counsel, based on his affidavit of indigency to represent him at the enforcement hearing. Mr. Miller did not establish his affirmative defense for his failure to pay child support, which is set out in Chapter 156 of the Texas Family Code. 157 of the Texas Family Code. He appealed that decision. The Court of Appeals in March of 2020 affirmed the finding that Mr. Miller was violated, was in contempt of court for failure to pay his child support. If Mr. Miller has appealed that, I don't know if Mr. Miller has what the status of that appeal is, Your Honor. But as far as this particular part of his facts allegations, that's banned by res judicata as well, Your Honor. This is nothing more than a dissatisfied litigant who has not been happy with the orders that have been entered by the family court in this case. Quite frankly, Your Honor, it's sanctionable, which is why we've asked the court to enter sanctions against Mr. Miller for the attorney's fees incurred by Ms. Dunn in connection with defending against this groundless and baseless lawsuit. Again, this arises out of his failure to reverse judgments of family courts through both the state and federal appellate systems. In each prior appeal, he's filed a petition to writ of mandamus with the Texas Supreme Court, which was denied. He has filed 3 removals, all of which have been remanded for want of subject matter jurisdiction. In fact, the third remand was in the case that had previously been remanded by the federal court. He remanded the same case twice, or removed the same case twice. Mr. Miller is engaging in nothing but delay tactics and, obstructive litigant behavior, and the court shouldn't tolerate this. It is Exhibit 1, Your Honor, for purposes of both attorney's fees and sanctions, permission to publish.
You may.
Exhibit 1, Your Honor, is a summary of the attorney's fees that, let's see, is this working? Hold on. Are y'all seeing my screen, or are you seeing something else?
We can't see it.
Can't see it. Okay, let me try.
No, we can. We can.
Oh, I'm sorry. Okay. Your Honor, my name is David Findlay. I'm an attorney with the Office of Worsinger, Nelson, Downing, and Anderson, LLP, and I've been licensed.
Wait, sorry.
Counsel, what? I thought you were just showing me an exhibit. Are you wanting to offer some testimony?
I'm wanting to offer it as evidence, Your Honor.
Okay. Well, if you're wanting to just offer the exhibit, that's one thing. Are you wanting to offer testimony to accompany the exhibit?
No, I'm just offering the exhibit as Exhibit 1, and I'm just laying the predicate for it, Your Honor.
All right. Well, if you're going to lay some predicate, then I need to put you under oath so you can.
Oh, that's fine.
Okay.
Yeah.
Will you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. Thank you. You may proceed.
With regard to the attorney's fees, Your Honor, my name is David Findlay. I'm an attorney with the Office of Worsinger, Nelson, Downing, and Anderson, LLP, and I've been licensed to practice law in the state of Texas since 2003. Exhibit 1 is a summary of the attorney's fees, expenses, and costs incurred by Ms. Dunn in connection with this lawsuit, together with redacted invoices of all work performed through May 6, 2021. All attorney's fees, expenses, and costs incurred by Ms. Dunn reflected on Exhibit 1 have been reasonable and necessary for the preparation of Ms. Dunn's defense against Mr. Miller's groundless suit. The invoices were made at or near the time the legal services were offered or performed by persons with knowledge of the legal services performed or to be performed. It is in the regular business practice for Worsinger, Nelson, Downing, and Anderson, LLP to make and keep the invoices. The invoices are redacted only to the extent necessary to preserve the attorney-client privilege. And at this time, Your Honor, I offer Exhibit 1.
Is there any objection?
Only that I believe it's irrelevant because the case was removed to federal court at the time that the complaint of acts, Your Honor.
That objection is overruled. Exhibit 1 is admitted. Counsel, you may proceed.
Thank you, Your Honor. And we're asking the court, that's the end of my testimony, just to prove up the predicate, permission to just resume argument.
Well, Mr. Miller, do you have any questions for Mr. Findlay related to his testimony on the attorney's fees?
I have other questions related to the incident at issue in this case.
I'm going to object to that, Your Honor. The only testimony I'm offering is with regard to the attorney's fees.
Sure. You certainly may cross-examine him on the attorney's fees, but if you don't have anything on that, then I'll let him finish his argument and I'll turn to you for your,
right.
I'll turn to Mr. Rochelle for any supplemental argument and then I'll get your response.
Yes, no questions about the attorney's fees.
Thank you, counsel.
Thank you, Your Honor. Mr. Miller is claiming that he's indigent and that's why he shouldn't have to pay attorney's fees. But at the end of the day, Mr. Miller should not be permitted to run to every court that he can find, file groundless pleadings, cause all these defendants to incur legal fees, whether public or private, to defend against these groundless accusations. Every last defendant in this case has filed a motion to dismiss. Mr. Miller's behavior is in filing this petition is frankly not supported in law by any reasonable standard. It's not based in any law or fact, and it's really just brought to harass everybody. And we would ask the court to enter sanctions against Mr. Miller for Ms. Dunn's attorney's fees. And with that, I'll reserve the rest of my time.
Thank you. Attorney Rochelle? I just assume get all of the arguments and then give Mr. Miller the opportunity to respond.
Your Honor, Mr. Findlay has fully presented what Mrs. Rochelle would wish the court to consider.
All right. Thank you very much. Then, Mr. Miller, you may respond.
Yes, Your Honor. The case that we mentioned in the last hearing, Brandt v. West, comes to mind. That was another case involving a family court horror story and probable conspiracy between corrupt attorneys. And I think that's what we're seeing here as well. It's shocking to hear that, again, Mr. Findlay blames me for everything that essentially he's done. He suggests that I could see my daughter under supervised by exercising supervised visitation. Well, I'm not, in the same way that governments should not pay terrorists, I'm not going to give any validity to a void order by observing it. That would completely undercut my my legal argument, number one. And I'm also not going to put my daughter in a situation of seeing me in what is essentially a prison environment. Also, I'm not putting money into a system like that. This order was absolutely void. That's at issue today. There is another case actually the U.S. Supreme Court just ruled on last year. That's Roman Catholic Archdiocese of San Juan versus Acevedo Feliciano, 18-921. That's U.S. Supreme Court, February 24th, 2020. And the ruling in that case states, once a notice of removal is filed, the state court shall proceed no further unless and until the case is remanded. 28 U.S.C. Section 1446D. The state court, quote, loses all jurisdiction over the case, and without jurisdiction, its subsequent proceedings and judgment are not simply erroneous, but absolutely void, quoting Kern v. Heidekoper. That's Kern v. Huidekoper, 103 U.S. Code. 103 U.S. 485 at 493, 1881. Every ruling states that if there is a removal and a state court judge holds proceedings or holds any kind of proceedings, issues orders, anything in a state court case, those rulings are void. The order that of June 7th, 2018 that Mr. Findlay was referring to is absolutely void. It has no legal standing, period. Therefore, I'm not going to observe it. He's essentially holding my daughter hostage. And his suggestion that my claim for personal injury and intentional infliction of emotional distress has no basis in law or fact is the most outrageous part of this entire, diatribe, essentially. It's shocking that he would even suggest that. I know Mr. Findlay has two daughters of his own, and I don't think he would appreciate this behavior of someone acting in a conspiracy to commit fraud and keep him from seeing his daughters by doing so. It is really amazing. My father, who died in 2019, at the age of 96, spent the last year and a half of his life without seeing his only grandchild because of this conspiracy between Mr. Findlay, Ms. Rochelle, and Ms. Dunn. David Findlay knew when he presented that order to defendant Diaz on June 7, 2018, that the court had no jurisdiction. I'd informed him that the case had been removed. He knew that the state court had no jurisdiction. He went ahead and gave that document to defendant Diaz to sign, and she did. He knew exactly what he was doing. He knew that Ms. Rochelle, his law partner at the time, had been through this exact same situation with Judge Plumley in 2016. And just as a side note, there is no record from that November 17, 2016 order entry hearing. As far as I know, there is also no record from the trial in that case. It's been beyond 3 years. I specifically requested in my 5th District Court of Appeals case that's now in the United States Supreme Court still. I requested from the court reporter, Francesca Duffy, a copy of the transcript from that November 17, 2016 order entry hearing. She initially gave me a price quote for that hearing, indicating, and that's in my exhibits as well, indicating that the record existed. And yet, when I requested it for the purposes of appeal, she suddenly claimed that it didn't exist. There's all kinds of misconduct going on in Ms. Plumley's court, not just, Judge Plumley's court, involving not only herself, but her associate judge, Defendant Diaz, and apparently her court reporter. There's all kinds of wrongdoing here. It's certainly not my imagination. I've cataloged all this in multiple appeals. The fact that the appellate courts are not protecting my constitutional rights and not serving their constitutional mandate is through no fault of my own. I can't force them to hear a mandamus, and I can't force either the Texas Supreme Court or the U.S. Supreme Court to hear these cases. Unfortunately, they don't. I want to get back to Mr. Plumley's.
But before you do that, Mr. Miller, 2 points. One,
Yes,
picking up on what you just said, I mean, if your view is that you have exercised your appellate rights and that those appeals have not turned out in the manner that you desire, but you've raised these issues, you've complained about these issues in those settings, do you also take the view that when you've exercised those remedies and they've not turned out in your favor, that it is appropriate for a trial judge such as myself to then go revisit those rulings, orders, decisions made by another trial judge and pass judgment upon them when the Court of Appeals has, in some instances, looked at them, in other instances decided they didn't have jurisdiction. But in any event, is it your view that another trial judge has the legal right to review and revisit and reverse a decision made by another trial judge?
Absolutely, I believe it's to do so. And my motion for declaratory judgment lays out the legal standard for issuing declaratory judgment. The a void order of any court can be reviewed at any time by another court. It's not a legitimate ruling that we're talking about. It's a fraudulent order that was issued without jurisdiction. And that order, both the orders that issue can be reviewed by you or any other judge. The Court of Appeals.
Tell me, what's the statutory authority for the position that a fellow trial judge has the ability to review a decision made by another trial court?
Yes, I'll have to pull up my declaratory judgment motion. I can bring it up pretty quickly,
Sure.
actually.
No problem.
Let's see here. And that's why I had hoped that we could get to the declaratory judgment before any of the other motions here, but here we go. There are several cases, and I'll go through this quickly.
Well, you know, I don't need a exhaustive list.
Sure,
If you
yeah.
would just tell me what is a binding case that has precedential value to this court that says that a trial judge, a
Absolutely.
district court judge, can review the decision of another district court judge and reverse, revise, or vacate that decision.
Absolutely, yes.
Yes.
First, Texas Civil Practices and Remedies Code, section 37.003. Case law is Old Wayne Mutual Life Association versus McDonough. That's 204 U.S. 8 at 16 in 1907. Citing Williamson v. Berry, 49 U.S. 495 at 496, that's 1850. Also, a collateral attack on a void judgment may be asserted at any time. That's P&S Stores Inc. v. Rivera, 379 Southwest 3rd at 267 and 272, 2012. And a void default judgment may be collaterally attacked through declaratory judgment seeking to declare the judgment void. That's Mungia, M-U-N-G-I-A versus Via Metro Transit, 441 Southwest 3rd, Southwest 3rd, 542 at 547. That's a Texas Court of Appeals, San Antonio in 2014. So there are several cases both allowing another court to review a void order and also allowing collateral attacks at any time. There actually is a federal case law, which I've cited as well, that states that a void order does not need to be declared void in order to be void. It just is void ab initio, as I've repeated in several of my briefs.
Yes. Okay, so the cases that you cited the court to, those are cases where a trial court has reviewed in order of another court, another trial judge?
Yes, the specific one is Old Way Mutual Life or Mutual Life Association versus McDonough. That one specifically says that another court can review the void order of a prior court.
Okay. And then before I lose my train of thought on this, I also want to get you to respond to the issue that we started talking about in the prior proceeding, which has to do with the language in the Brad case that is cited in other cases. But the proposition is that the term jurisdiction, it has a connotation in judicial immunity analysis that is entirely different from its usual meaning. And what you seem to be offering the court is an analysis of whether or not Judge Plumlee had jurisdiction when the case was removed before it was remanded. And what I'm wanting to give you a chance to respond to are the arguments that have been put forward that analyzing whether she had jurisdiction in terms of subject matter jurisdiction is different than the court analyzing whether or not she proceeded with the entry of the order in the absence of any jurisdiction for the purpose of a judicial immunity analysis, which, as we talked about in the prior proceeding, involves whether she had jurisdiction necessary to sign an order of the kind that she signed as the presiding judge of the 330th. And so I want to just give you a chance to expound upon your position there.
Yes, I believe the language of Bradley v. Fisher and is very clear that the judge is liable to suit and damages when acting in absence of all jurisdiction. As I said in the prior hearing, Brandt v. West was a case where there was a motion to recuse, and then the judge proceeded after the motion to recuse. That's not the same circumstance, and there's not, as far as I know, federal case law that is as black and white and clear cut as the case law in Bradley v. Fisher and Stump v. Sparkman and Morales v. Waco, which specifically says that when a judge is deprived of immunity, as occurs in a federal removal, when they act without jurisdiction, as occurs in the case of federal removal, they are deprived of immunity for those acts. I think that's the case law is very clear. I think that Mr. Graydon wants to muddy the waters about the meaning of jurisdiction. It reminds me of Bill Clinton's statement. It depends on what the meaning of the word is. I don't think that the Supreme Court made a mistake in its diction. I think they chose the diction they did, which was the word jurisdiction, meaning exactly what it meant. I don't think there's a different meaning of the word jurisdiction when it comes to judicial immunity.
And you hold that view despite the fact that these cases say the exact opposite?
Well, I think the only cases that say the exact opposite are ones that don't apply to the same situation. And as I said, the U.S. Supreme Court, Bradley v. Fisher, says in no uncertain terms that when a judge is deprived of jurisdiction, they are also deprived of immunity for the acts that they are performing in a non-judicial capacity without jurisdiction. So I think that they are talking about two different issues. I understand that there are even Stump v. Sparkman and Morales v. Waco state that if a judge is acting while a case is proceeding, that they might be immune from suit even for criminal acts, but that's not the case here. There is one exception to judicial immunity, and that is the case of jurisdiction, especially in cases of removal. That's one that has been clarified by the U.S. Supreme Court multiple times now. I don't believe that the Brandt case applies to this case. Obviously, Defendant Plumlee, in her capacity as judge, has jurisdiction over family law cases. But if there's been a federal removal, she is deprived of jurisdiction in that specific case. If she then proceeds, she is also deprived of immunity for anything she does without jurisdiction. I just think that the case law is very clear, and there really is no conflict between Brandt v. West and similar Texas cases because none of them have to do with federal removals and jurisdiction during a removal.
Thank you for responding to my questions.
Yeah.
Any additional arguments you wish to bring to the court's attention?
Yes, I'll just go quickly. Again, Mr. Findlay went on at length about res judicata, but it does not apply because the issue, really, the main question here is, were these two issues signed, two orders signed by Judge Plumlee on November 17, 2016, and the order signed on June 7th, 2018 by Defendant Diaz, did the court have jurisdiction? Did those two individuals have jurisdiction during those acts? And I believe they haven't. And that issue has never been adjudicated by any court. As Mr. Findlay noted, none of the top Texas Supreme Court and the U.S. Supreme Court declined to hear those cases. The only one that mentioned it was the ruling in the Texas 5th District Court of Appeals, and they said they didn't have jurisdiction. And I'll read their ruling. It's Section 2, and this was actually attached to my exhibits and also to Defendant Plumlee's exhibits in the last hearing as Exhibit B. And the quote was, "Father challenges orders and hearings that are not included within the scope of his appeal." So they ruled that those two orders were not included in the appeal that they were reviewing. And to continue, to the extent that Father's arguments address the order resolving Mother's motion to modify his visitation in custody, his appeal was due 30 days.
Mr. Miller, remember that Ms. Williams has got to get the record down.
I'll slow down, sorry. To the extent that Father's arguments address the order resolving Mother's motion to modify his visitation in custody, his appeal was due 30 days from the date of that November 17th, 2016 order. And then skipping ahead, we lack jurisdiction over proceedings unrelated to the judgment, and accordingly overrule Father's 11th issue and confine our analysis to the judgment and the proceedings from which it arose. And the judgment they're referring to was Defendant Plumlee's enforcement ruling, which Mr. Findlay alluded to in a Title 4D enforcement case. The 5th District ignored the other two orders altogether. They didn't even mention in their order, their final opinion, the June 7th, 2018 order. They just essentially just didn't mention it. I've actually have an exhibit in my exhibits that is the ruling, because I filed a motion, essentially a motion for declaratory judgment or to stay the June 7th, 2018 order in that appeal. And Justice Lana Myers of the 5th District Court of Appeals said that essentially we question whether we have jurisdiction over that order, and she didn't rule on it. So these two orders and the validity of these orders and the jurisdiction during those orders has never been adjudicated by any court. Therefore, res judicata does not bar this court, for the reasons and supported by the case law I cited earlier, from considering the validity of Defendant Plumlee's purported order of November 17, 2016, or Defendant Diaz's purported order of June 7, 2018. I want to go on a little bit about attorney immunity, which Mr. Findlay claims. And I think that Mr. Findlay believes that he's entitled to really do anything he wants, and because he's under the blanket protection of immunity, but I don't think that applies in this case. First, as I argued, not even judges have civil immunity for acts taken in the absence of jurisdiction under Bradley v. Fisher, Stump v. Sparkman, and Morales v. Waco, which I've briefed in my response. Similarly, attorneys have no immunity for criminal acts that are beyond the scope of client representation. And the Texas Supreme Court ruled in Canty Hanger, LLP versus Boyd, which Mr. Findlay also cited. And the quote from that ruling is, attorneys are not protected from liability to non-clients for their actions when they do not qualify as, quote, the kind of conduct in which an attorney engages when discharging his duties to his client. The Canty Hanger ruling continues. To that end, some courts of appeals have broadly stated that attorney immunity does not extend to an attorney's knowing participation in fraudulent activities on his client's behalf, which I am alleging that Mr. Findlay did and Ms. Rochelle did on behalf of Ms. Dunn. And then that quote continues at 483 from Canty Hanger. An attorney is liable if he knowingly commits a fraudulent act or knowingly enters into a conspiracy to defraud a third person, which happened here. I am the third person. In another case, more recently in 2018, in Youngkin v. Hines, and that's number 16-0935 at 10, the Texas Supreme Court ruled that, quote, though attorney immunity is broad, it is not limitless, unquote. And again, in a 2019 case, Texas Supreme Court case, Bethel v. Quilling et al., and that's number 18-0595 at 9 through 10. And the quote is, we have long recognized, however, that attorney immunity is not boundless. And they're quoting Poole v. House and TC Rye, or y.co, and that's 58 Texas 134 in 1882. Holding that attorney immunity did not protect actions taken, quote, for the purpose and with the intention of consummating fraud upon the appellant. And in this case, I would be the third party appellant. Both Ms. Rochelle and Ms. Findlay were aware that I've removed my case to federal court on those two dates, November 17, 2016 and June 7, 2018, prior to their acts of securing signatures from a purported court. They knew that the 330th Family District Court had lost jurisdiction, was deprived of jurisdiction at that time. They knew they were engaging in fraud and also a conspiracy to commit fraud, because the three of them had been working together since 2013. Both Mr. Findlay and Ms. Rochelle have been representing my ex-wife, defendant Dunn, since that time. There can be no doubt that Ms. Rochelle and Mr. Findlay securing execution of a document by deception, which is a crime of fraud under Texas Penal Code Section 32.46, and then sending the document to me and to others as if it were legitimate, which is a crime of fraud under Texas Penal Code Section 32.48, that's simulating service or process. Those two acts are foreign to the duties of an attorney, absolutely. And certainly they have no immunity for these acts, and especially when a judge would have no immunity for the same acts. It's hard to even fathom a situation where a judge would not have immunity for a criminal act or act of misconduct in which an attorney would for the same act. That makes no sense. I believe that I have established a claim for fraud, contrary to what Mr. Findlay alleges. The misrepresentation doesn't necessarily have to be made to me, and I've set out the case law in my response for that as well for this hearing. On both of those dates, November 17, 2016 and June 7, 2018, Ms. Rochelle and Defendant Findlay, on behalf of Defendant Dunn, made a material representation that they were authorized to proceed in state court, and they failed to disclose the fact or act on the fact that I had removed my case to federal court. The representation was false. The representation was known to be false when they made the representation to the court or submitted the documents, the purported orders for signing. Because I had already served both of them with removal documents prior to their engagement in these acts. The representation was made with the intent that the defendants Plumlee and Diaz would sign their fraudulent orders, which they did, and the other parties, defendants Plumlee and Diaz, signed the orders upon the misrepresentation, and as a result, I suffered financial injury and injury to my constitutional rights. There's plenty of basis for fraud here. And for fraud by non-disclosure as well. They failed to disclose to at least Defendant Hockaday that the purported orders that they'd sent them were void, and they knew they were void because I told them. They had a professional and legal duty as attorneys to disclose the fact that they were sending essentially products of a crime as purported orders. They knew that Hockaday was going to act on these void orders. And indeed, they induced Hockaday to enforce them, and they still are 3 years later. Hockaday relied on this non-disclosure for its action, and I was injured by Hockaday's acting without knowledge that they were void, at least initially. I believe that Hockaday had plenty of evidence, because I've informed Hockaday as well that these orders were void, and they're still acting on them, so that's a different issue. But the defendants were certainly negligent in all of these actions. There's copious evidence for conspiracy. There were two or more people involved in this: Dunn, Findlay, Rochelle, and defendant Diaz, and Plumlee to begin with. There were two or more people involved with the object of rights deprivations, which I have suffered. Demonstrated meeting of the minds because they knew what they were doing. They obviously had been through this before once with Miss Rochelle and defendant Plumlee, and then defendants Findlay and Diaz then engaged in the same conduct. I actually filed a special appearance after defendant Diaz signed those orders, challenging jurisdiction during my removal. Defendant Diaz denied my special appearance. I filed the de novo, and Judge Plumlee actually denied the de novo, which is not allowed under the Texas Family Code. You are required to hold the de novo hearing. So clearly they had discussed the incident and had made decisions on what they were going to do about it afterward. And my de novo appeal was denied. So there's all kinds of evidence of conspiracy that have gone into in my my pleadings. As I said, it's outrageous that that defendants Dunn, Findlay, and Rochelle believe that I should be sanctioned or awarded attorney's fees for filing what is certainly a case with very clear grounds in both the law and in as far as removal law and judicial jurisdiction during a removal, and immunity, lack of immunity, and deprivation of immunity during a federal removal on the part of a judge, a lack of attorney immunity for any acts that involve fraud, an intentional commission of fraud. It really is ludicrous that they would suggest that. However, this is the kind of thing that that happened in Judge Plumlee's order back in November 17th of 2016. Similar things. That suit was filed completely without stated grounds. I objected to that suit proceeding on the fact that it was groundless. Judge Plumlee denied that objection, denied that motion to dismiss. It proceeded. It went on for a year and a half, chewed up a year and a half of my life. And at the end, Judge Plumlee signed an order, or a fraudulent order, giving more than $55,000 in levies against me, including $25,000 in attorney's fees. It's just insanity. This entire case has been a massive exercise in fraud. But the two acts for which defendants Diaz and Plumlee and defendants Rochelle and Findlay are without immunity are the signing of these two orders. It's quite clear. As we've been through before with the initial hearing in this case for defendants Leindecker and Taylor, assessing attorney's fees or monetary sanctions against an indigent party is precluded by Boyce v. Alzada. That's 595 Federal Seconds. 595 Federal Seconds, 948 and 951, Note 6. That's Federal Fourth Circuit, 1979. The quote is, "Persons proceeding in form of pauperous are immune from imposition of costs."
I'm sorry, Mr. Miller.
Just where you were reading from the case, I think that's where we need to pick it up.
I'll start then. Persons proceeding in form of pauperous are immune from imposition of costs. And that's in keeping with Texas Rule of Civil Procedure, Rule 145, which is designed with the intent to allow access to the courts to indigent parties. I will say that when my ex-wife, defendant Dunn, started our divorce case in 2013, I was not an indigent party. I was living in a house that I had, helped pay for. I spent 13 years helping grow my ex-wife's business. I was in not the same financial straits, and my current financial situation is a direct result of the actions, fraudulent actions often, of defendant Dunn, defendant Findlay, and defendant Rochelle. Blaming the victim is an absurd tactic, but that's what he's trying to do. I think that also the statute of limitations to cover this we're well within the statute of limitations for fraud for both of these incidents, and certainly within the statute of limitations for personal injury, infliction of emotional distress, conspiracy for the act on June 7th, 2018, based on the date of filing of my federal complaint And of course, I refiled within 30 days of dismissal just to preserve the tolling of statute of limitations there. So I don't think that's an issue. I argued in my response that I object to the dismissal of other incidents that are beyond the statute of limitations on 14th Amendment grounds. And I'll reiterate that here. I think that any reasonable application of due process precludes the allowing of the statute of limitations for tortious and fraudulent and criminal acts to run while one or more conspirators keeps an indigent party involved in litigation resulting directly from their abusive conduct, which is what's happened here, thus allowing the conspirators to escape liability for their tortious acts. Defendants Dunn, Findlay, and Rochelle should be held liable to suit for personal injury and conspiracy, as well as fraud, and with regard to all of their acts, including those for which the statute of limitations have run. And generally, they need to be held liable and accountable, because it's almost impossible to hold an abusive judge or abusive attorneys or attorneys indeed that engage in criminal acts accountable. We just happen to have the one exception to immunity that exists in this case, and that is federal removal and jurisdiction during federal removal. And that is a critical point. I think that, and that's really the all that I have to say. I do have some exhibits that I'd like to present.
But before you do that,
Yes, sure.
I want to go back to the illegal position that you'd raised here.
Yes.
Where you said that you provided support in your brief for the idea that the representation, the alleged false representations that were made to other people, not to you, but you, I believe your statement was that the representation did not have to be made to you. And you said that you cited some authority in your brief to support that. I have your brief up. Would you tell me what case you are making reference to that supports the idea that the
Yes, sure.
false representation did not have to be made to you or your agent?
Yes, I will find it quickly in my response. Let's see here. Let's see here. Sorry.
If it helps, I think the discussion about the fraud claim in your brief starts at the bottom of page 7.
Yes, let me pull that up. Okay. Actually, that's I see I'm seeing removal at page 7. Oh, I'm sorry, I'm looking at the wrong document. Oh, that's why. Sorry, let me pull up my pleading for this. I was still looking at Judge Plumley's document. So there we go. Okay. All right. Okay, page 7, yes. The case law cited there was in RA First Merit Bank in A, it's 52 Southwest 3rd 749 at 758 Texas Supreme Court 2001. Formosa Plastics Corp. USA versus Presidio Engineers and Contractors, Inc. That's 960 Southwest 2nd 41 at 47, Texas 1998. Ernst & Young LLP versus Pacific Mutual Life Insurance Company, 51 Southwest 3rd 573 at 577. That's Texas 2001. All of those cases set out the elements of fraud.
Are they cases where the fraudulent representation was made to someone, the purported fraudulent representation was made to someone other than the plaintiff?
I can't recall specifically, but I can say that with regard to fraud, false representation to a third party is the basis of simulation of legal process under the Texas Penal Code. So it would seem contrary to logic to suggest that a civil fraud could not be made in an incident involving a false representation to a third party or to a third party that affected the second party, essentially.
Okay. And thank you for responding to my question,
Yes,
Mr. Miller. You were about to talk about some evidence, and I wanted to remind you of something we talked about before, which is that the court is limited in terms of the record that the court can review in connection with a Rule 91A motion to dismiss.
Yeah.
It's appropriate for the court to consider evidence about attorney's fees if those are requested. I appreciate your opposition to their requests, but I'm not sure what you were going to show the court, but the court really has to limit its analysis to the pleadings.
Actually, with regard to the exhibits, I've stated all of the issues that the exhibits would demonstrate anyway. The date stamps are of course important, but that hasn't been disputed by any of the other defendants, so I don't think it's necessary for me to present those, Your Honor.
All right. Thank you, Mr. Miller. I will give just a final rebuttal of just a few minutes to counsel, Mr. Findlay, if you'd like some rebuttal.
Thank you, Your Honor. I'm going to answer the question that Mr. Miller didn't answer with regard to the fraud. So I actually read the Henry First Merit Bank case, the Formosa Plastic Corpse case, and the Ernst V. Young case. In all three of those cases, the representation was made to the opposing party. The court can read the cites and determine which representation of that is correct, but in my reading of it, the representations were each made to the opposing party. So Mr. Miller has not identified the exception that the court was looking for, at least not in those cases. So I'm just going off the cases that he cited. With regard to his complaints about, the wrong orders, things that happened in the 2016 order, he's waived those arguments. He could have filed a direct appeal of that order in the Texas Court of Appeals in Dallas in 2016. He chose not to.
I'm sorry.
I'm sorry. He chose not to. Instead, he goes on. He thinks that he had the right to remove the case to federal court. Well, turns out he doesn't. He under the removal statute, he has 30 days from the date of service of summons to remove the case to federal court. It's not when he discovered that removal was a thing you can do. Instead, it is it's 30 days after service of citation, and that happened in 2015. And in the Parish v. State case that that Mr. Graydon cites in his brief, the court the Court of Appeals actually analyzed, okay, what did the federal courts say about this? Well, the federal courts on balance say that, well, if you didn't comply with the removal statute, you never deprived the court of jurisdiction in the first place. That's exactly what Mr. Miller did here. And actually, if you want, Your Honor, I'll give you the cite for the Parish v. State case. That's 485 Southwest 3rd 86. And I'll draw the court's attention to pages 89 going on to 90, where it talks about no state, Texas state court has considered. And you can go into the paragraph as to where they're trying to make heads or tails as to whether or not there is any authority for this. We agree with the Attorney General and the balance of the federal courts that say that if you don't comply with the removal statute, you don't have a valid removal. Mr. Miller might protest that, but no judge he hasn't brought this up in any of his appeals of the prior orders. And so I think he's waived that issue to some degree. Now, with regard to the attorney immunity claims, he still is misunderstanding the standard here. It's the kind of things that that an attorney takes, not whether or not that action was wrongful. Mr. Miller just admitted to the court. I'm complaining about Findlay and Rochelle presenting an order to the court to sign. Well, that's what attorneys do. And he's complaining about judges signing orders. That's what judges do. So he doesn't quite grasp the fact that, he's not saying that, there was something else going on outside of the representation that's actionable here. And so his argument that somehow the attorney immunity and judicial immunity defenses don't apply doesn't make any sense. With regard to the, let's see if there's anything else I need to talk about. Oh, with regard to the, whether he says that the Court of Appeals hasn't decided as to whether or not the November 16th ruling was somehow invalid. The Texas Court of Appeals rejected that. On page 7, going on to page 8, they actually say that his appeals with regard to the remand orders had no impact on Judge Plumlee's jurisdiction. And then he says remand orders premised on the absence of subject matter jurisdiction, as each remand order in this case are, quote, not reviewable on appeal. And then it goes on to conclude at the end of that section that no jurisdictional defect exists regarding the judgment. It's from the Dallas Court of Appeals. In the opinion on his appeal 0905-19-00197-CV, Dallas Court of Appeals, March 26, 2020. That's the immediate Court of Appeals that Mr. Miller would go to if he decides to appeal your judgment here. At the end of the day, Your Honor, Mr. Miller is not happy with what's happened in the family law case. He believes that there's this grand conspiracy out to get him, and there's just simply not. He hasn't pled any cause of action sufficient to justify this lawsuit, whether against Ms. Dunn, whether against Ms. Rochelle, whether against myself, or quite frankly, any of the other 12, 13 defendants in this case. Quite frankly, each and every motion to dismiss that you're considering should be granted, and Mr. Miller should be sanctioned for filing this lawsuit and costing these parties, some of which are not wealthy people. While I'm not personally affected by the attorney's fees so much, there are other parties that are. And the court should take that into consideration when deciding on whether or not they're entitled to attorney's fees. They're spending time and resources that they don't necessarily have to defend against someone who's just mad at the world and shaking his fist and demanding that someone do something that quite frankly, there's no jurisdiction to do. And to the extent other courts have already decided it, and to the extent Mr. Miller's waived his complaints. Your Honor, we just simply ask that you dismiss the case and consider sanctions. Thank you.
Your Honor, I have to object on one issue because I believe it's a fraud on the court. Mr. Findlay is misrepresenting the judgment of the Fifth District Court of Appeals in case number 05-19-00197-CV. He keeps claiming that the removal did not affect the judgment, and he thinks he's referring to the judgments, the orders signed on November 17, 2016 and June 7, 2018. That is not the case. As I've said, the judgment in that they're being referred to in that ruling is only the Title 4D child support enforcement judgment. That is the only thing they ruled on, and they were basically talking about the removals not affecting that. Just one other related issue, that the federal courts never ruled that my removals were invalid due to timeliness. No court has ever suggested that. There's no evidence for that. The opinions in those federal cases state that in every instance that they were remanding due to subject matter jurisdiction issues only, nothing at all to do with timeliness. There is no evidence for that as well. That's all, Your Honor.
Thank you. Mr. Rochelle, is there anything else before the court wraps the proceeding?
No, Your Honor. Mr. Findlay has well represented us. Thank you.
Your Honor, I do believe Mr. Graydon raised his hand, and I'm actually okay with Mr. Graydon speaking up on a point that Mr. Miller just made if the court's inclined to hear him.
Well, you both have referenced prior hearing and with Mr. Graydon, and so the court is happy to hear from Mr. Graydon. Go ahead.
Your Honor, I'll keep this very brief. When Mr. Miller tells the court that the November 17th, 2016 order was not addressed in the Fifth Court of Appeals opinion, that is simply inaccurate. The Court of Appeals decided that it was not before them because the time to appeal that order had expired, and that was the reason why it was not before them. Not because it wasn't getting ruled on at all, but because the judgment was final and because the time limit to appeal it had expired, notwithstanding Mr. Miller's arguments that it should be void because it was improper. The court heard his arguments and said, that is not before us because the time period to appeal it has elapsed. Mr. Miller has said that if an order is void, that you could attack it at any time. And it is therefore a very reasonable conclusion to make that because the Court of Appeals thought that this was untimely because it lacked the jurisdiction to consider that argument, that the Court of Appeals did not consider that order to be void. And so this is in that Court of Appeals case. We filed it as Exhibit B to the plea to the jurisdiction. And it is on, I believe, the second page of Exhibit B. Moreover, to the extent that there has been argument regarding the Supreme Court case from last year and the effect of removal on jurisdiction, that is in a bankruptcy proceeding, which is an entirely different context with the proceedings here. Further, it does not deal, among other things, with the context of what is all jurisdiction for judicial immunity purposes. I think that is very easily distinguishable from the facts that are presented in this case and the lack of a bankruptcy interference with the state court proceedings in this case. So that is all I would include for the court because I believe that an inaccurate representation has been made.
Thank you all. I appreciate the arguments. I'm sorry.
Oh, sorry. I have one comment as well on the same grounds to Mr. Graydon.
You may, Mr. Miller.
Thank you. It's definitely a leap of logic to suggest that the Fifth Court of Appeals did not consider that order to be void. Simply, as Mr. Graydon said, they didn't consider it at all because they just looked at the date of purported issue. I actually mandamused that order. The whole purpose of mandamus is to address orders for which there is no other remedy on appeal beyond 30 days. They chose to ignore it. They didn't consider it to be not to be void. They didn't consider it at all, and that's the point. There was no adjudication on the validity or invalidity of that order. That's all, Your Honor.
Thank you all. If there is nothing further, you all are excused. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.